Welcome to the FCA 101 series from the Federal Bar Association's Qui Tam Section. This is a video series on the basics of the False Claims Act. This is episode 3 of 8, and it is going to cover the role of the relator. Our panelists today include Janel Quinn, who is a principal at the Employment Law Group law firm, where she represents whistleblowers who report fraud on the government. Janel joined the firm in 2012 and has spent the majority of her time there working with individuals who want to expose and halt schemes to cheat U.S. taxpayers. She also pursues employment claims for clients who are fired or otherwise punished for raising concerns about fraud, wrongdoing, or misconduct in the workplace. We also are joined by Armen Adzhemyan, who is an assistant U.S. attorney in the Northern District of Georgia. And there he focuses on affirmative civil enforcement matters. He is also the Civil Elder Justice Coordinator. And prior to joining the U.S. Attorney's Office, Armen worked as a litigation associate in the Los Angeles office of Gibson Dunn. Ellen Persons began her law practice at a large law firm in Atlanta, focusing on government investigations and white-collar defense. She then became an assistant U.S. attorney in the Northern District of Georgia's Civil Division, focusing mainly on healthcare, financial, and education fraud against the United States. But in 2017, Ellen returned to private practice and is currently a shareholder in Polsinelli's Atlanta office, and she focuses her practice on government investigations and white-collar defense. The moderator of our panel today is Jason Marcus. He's a founding member of Bracker Marcus, LLC in Atlanta, Georgia. Since 2008, Jason has exclusively represented whistleblowers in Qui Tam claims under the False Claims Act, SEC, and IRS whistleblower statutes. He's on our advisory board of the FBA Qui Tam Section, and he's the founder and chair of the Young Lawyers Division for the Taxpayer Against Fraud Education Fund. And with that, I'll turn it over to Jason.
Thanks, Kate. Thank you, everyone, for joining us. I'll kind of introduce this panel, something one of my colleagues recently said to me in the Relators bar, that he feels he has 3 jobs when he's representing whistleblowers, and that's to protect them, reward them, and empower them. So we're hoping to speak on each of these 3 topics today, and Ellen, of course, will speak on how to avoid at least the reward part. So thanks, guys. Janel, let's start with discussing what is the psychology of the whistleblower in your experience? How do they find you and become relators?
Sure. So a lot of my whistleblowers find me because they have been retaliated against at work for trying to raise concerns. And many times those concerns, at least in our view, are valid concerns and could possibly lead to liability under the False Claims Act. Not all the time, but a good portion of the time. In terms of a whistleblower psychology, I think a lot of people will say that whistleblowers are rule followers, and I absolutely think that that's true. And in my experience, whistleblowers are very black and white. They hold strongly to their convictions. Sometimes there's not a lot of understanding of nuance or gray area, which on the one hand makes them excellent when they're right, great witnesses. They fact find and they observe, and then they apply what they're seeing to the rules, and they're really steadfast in their narrative and their testimony. Sometimes that also makes it difficult because in addition to being rule followers and, being very black and white, they're also, especially by the time they get to me, a little skeptical of things, right? So sometimes trying to overcome or explain to them that, well, I know you think this is black and white, but maybe there's some areas of gray. Sometimes that can be a little difficult as well. So that's, generally how I have found a lot of whistleblowers, although, of course, not 100% across the board. People and whistleblowers, like I think all groups of people, have a lot of diversity amongst them.
Thanks. Yeah, and I'll add to that. In my experience, what I think will surprise a lot of people is that very few of my clients come to me because they're looking for a reward. In fact, a lot of them don't even know there is a reward. I think probably the two reasons most come to me is because they're looking either to right or wrong. Like you said, they work for some place and they feel like there's just something wrong that needs to be fixed. Or a lot actually come to us to protect themselves because once they figure out they were part of some sort of scheme and they think, gosh, I don't want to lose my license or have them throw me under the bus later. So that's the Relators bar's perspective. Ellen, what's the defense bar's perspective? What's a relator to you?
Sure, Jason. Well, that's a little bit of a loaded question. I'll reserve some of my views, but generally speaking, it's what Janel said, which is, it's very often it's a disgruntled employee. I think approximately 70% of Qui Tams filed are, employees who have either been fired or, are disgruntled in some way. And I think most of them are just sort of your rank and file employees. I think something like 59% are that, about 27% are middle management, and then only about 4% are upper management. And obviously when it's upper management, from the company's perspective, that's a lot more concerning sometimes. But it often depends on the facts of the case, what we think of the relator, and also the size of the client we're representing, to be honest. I've had some smaller clients who take it very personally and think it's sort of a vendetta against them as a person when a relator files a Qui Tam. Some of the bigger companies, I don't want to say it's a cost of doing business, but they're a little bit more attuned to the fact that this happens. But it's sort of what you all have already said. It's your typical disgruntled employee. And often, as Janel said, they do see things very black and white, which may be great from y'all's perspective. But in our view, lots of the areas where there are Qui Tams and where there's fraud involved, there is some gray. So we prioritize that and try and focus on the gray areas and why the relator is wrong.
So Ellen, if you have middle manager Joe who says, man, I can't believe they're doing this. This is just wrong, and reports it internally, and just feels like they're not getting the response they want. How do you keep them from becoming a whistleblower? How do you keep this an internal matter?
Yeah, well, I mean, I guess that you hit the nail on the head. First of all, like if they don't feel like they're not being heard, you're asking for them to become a whistleblower. I think the main thing that any entity or company can do is to make sure that they educate their employees, that they have a robust compliance program in place, and one that is actually, has teeth to it, right? Not just that you are checking all of the boxes. And I'm sure Armen will have views on that, but you want to make sure that your employees feel like there's an avenue where they can make reports, and that if a report is made, it's taken seriously, it's investigated, and that there's some sort of action taken if that's necessary. I think the very worst thing you can do is not educate your employees, not have a compliance program in place, and literally just sort of do the song and dance without having any actual teeth to what you are saying they can do, right? Nobody likes to feel like they're not heard. And if they feel like it's falling on deaf ears, the very first thing that they're going to want to do is report it. And that's when a company gets in trouble and has to deal with a Qui Tam.
Thank you. So I'm going to talk a little bit about what happens when a relator walks through our door, potential relator, I should say. So obviously, this whistleblower comes to you with concerns about what's happening at their practice or their business. You want to get all of the facts, right? You want to really dig into every detail of the fraud that they're alleging. And I'm going to when we get into the disclosure statement section, I'll get a little more into what other, how exactly you do that. But that's obviously the first factor, right? Is what is the fraud and how egregious is the fraud? Because there's, as you saw in a previous panel, there's this materiality standard. And if they're using the wrong color of, stapler, that's not going to be something that excites the government. So you're trying to not only figure out, is this going to be material, but how sexy is this going to be when I bring this to Armen? Is he really going to care that this is going on? The second factor you're going to look at is the size of the case, right? If it's a, $50,000 case, it's not going to be as exciting for anybody, and maybe not a great business decision, as opposed to a case that's worth potentially millions of dollars to the government. And then, of course, you're going to look at what evidence does your client bring to the table. So you kind of look at, as you get more experience in this area, you look at those three factors and sort of balance it out. a case can be small, but if it has really egregious fraud with patient harm, it's going to be very interesting, even though there's not a lot of damages. Whereas a case that's, a $10 million, $100 million kickback case, but no one's really getting harmed, still $100 million of fraud to the government. So you want to evaluate all of these factors. And you also want to look into the background of your relator, right? You want to find out, especially if they got fired, why did they get fired? What are the circumstances? Even if you don't have a retaliation claim, you can expect at the end of the day, they're going to start talking bad about your relator. So you want to know these things. One sort of side point to that is always find out if there's been a bankruptcy. A lot of good relators attorneys don't realize this, but if at any point there's a bankruptcy during a time that your client should have been aware of the fraud, you're arguably stopped if you don't include it in the bankruptcy. And obviously you need to balance that out with seal. So you're going to want to bring in a experienced bankruptcy counsel for that. But knowing that ahead of time, because no one thinks to bring that up, right? Like, oh no, 2 years ago I had a bankruptcy. You think, well, I'm filing now, but it actually could have real ramifications to your case. So once you've determined, once you've gotten all this explanation from your client, obviously you want to discuss the process of how the False Claims Act cases work. You want to make sure they understand that this is going to take a number of years. It's going to take, possibly months even to put it together with your client, and go over the risks and rewards with them. So, we're not going to get into the details of how a relator share works, but as part of protecting your client, they need to understand the risks to them. That includes potential reputational harm. If this case comes out and they get pegged as a whistleblower, what's this going to do to your career, right? Another potential risk is criminal liability. There's not immunity that comes with bringing one of these cases. So if you're, the operator and the originator of this fraud and you bring a case, you're telling the government everything you know about the fraud, right? And so you're potentially putting yourself at risk for criminal liability. So you want to make sure they're on board for this. It's not just a free ride. You're not just filing a case and waiting and hoping that, it pays off. Once you have them on board for that, obviously you want to research the law on the issue, because at least at our firm, we rely very heavily on our clients to know what they're talking about. But even the most knowledgeable, experienced clients do not necessarily know the nuance of the law. You're going to find this a ton with anti-kickback statute and Stark law, with a zillion exceptions. Your client's like, this is a clear violation because I read it on a website or I got it in a training. And then you dig into it more. The last thing you want to do is bring a case to the government and they call you the next day and say, Jason, this is not even against the law. That's just embarrassing. You've wasted everyone's time and money. On that point, I'll just add it as a practice pointer. Research if it's Medicare and Medicaid, understand it's different programs with different regulations. You think something violates Medicare, it must violate Medicaid, not necessarily. Do your work, do your homework. Obviously, once you've got that all in place, you're comfortable, you've got a case, you start drafting your disclosure statement. I'm going to pass this on to Janel. Janel, what other steps does your firm take in the investigation process?
Yeah, so we pretty much do all of the things that you just said. A couple of those things we take even a little bit further. So for example, in terms of getting all of the facts and the narrative from our client, we have both an attorney and an investigator, like a private investigator, interview the potential client. Because, right, the attorney comes at it from the legal standpoint and really does kind of trust the client to be the expert of the facts and the industry. And then the private investigator, we want them to look at it from a very skeptical kind of lay person standpoint. Like, is this something that passes the sniff test? Is this, are the allegations they're making conclusory? Do they really have the goods to back it up? Things like that. We, in addition to asking the relator about their background, we do run a full background check and investigation and credit check and investigation, because it's not just if they have declared bankruptcy previously, but if they might, for example, declare bankruptcy once the seal is already in place. That's also tricky to deal with. So we do that. Neither of those things I would say are dispositive in most cases, although I have had a few cases where something came back on the background check and we, regardless of whether their allegations were right or not, didn't feel like we could adequately represent this person, to the government as a relator in a False Claims Act case. We will also, if there's any questions about the solvency of the defendant or recoverability of damages, we'll do a, kind of like a background or corporate entity search into the defendant. Obviously it's harder to view the defendant's money, but we find out what we can, especially if it's a publicly traded company, we'll take a look into all of that. So we really do kind of do a deep dive on those issues. The other thing that we will do is we will ask sooner rather than later to see their documents. And, maybe Armen has some feelings on this as well, but typically we want to bring documents to a filing to the government to corroborate our client's allegations. And in instances where there are not documents, I really want a witness interview. And so we'll ask potential clients early on, well, who would potential witnesses be and what do you think they would say? And we don't always contact witnesses right away, but when we go to file, I'm also looking to hand over a witness list, or at the very least, a list of people that, if Armen goes and searches emails, these might be custodians, or these might be names that he comes across, things like that. So, sometimes we'll do witness interviews and we're just clear with them about who we're looking for. If it's someone who is management or in any way, could bind the company, I don't want to talk to them at all, right? If they could potentially be represented by Ellen, I don't want to talk to those people. If they're going to go back and tell the company right away, that's probably not going to be a very good witness for us because, we want to keep our investigation quiet and hand over, a quiet case to the government. If it's people that they just liked at work but don't know anything of the allegations, that's also not really helpful. So, we have a conversation with them about who we're looking for, why we're looking for them, and kind of what we would have to say to the potential witness when we approach them.
Thanks. And just as a counterpoint, thinking back over my career, I have rarely, if ever, interviewed witnesses during the investigative process. It's just kind of, depends on your style. There are risks, which we're going to talk about in a minute. But it's just, to me, I feel like, well, Armen can go talk to this person and get the information better than I can. But obviously, if you're, not extremely confident in your case yet, that your client has a real case, obviously you don't want to similarly waste the government's time filing a frivolous lawsuit. So that also makes sense.
I will also say it is 50-50 for me in using witness interviews to bolster a case versus kill a case, right? If I have a case that's coming in the door and I'm thinking maybe, right, this sounds like something's going on, but I just have some questions. I think as Ellen pointed out, most relators are employees, maybe not happy with their employer, and probably, right, lower level rank and file employees. And so I'm thinking, well, I believe what they're saying, right? I believe what they're seeing, but maybe there's something going on behind the scenes, or maybe there's another piece of the puzzle that they're not seeing that corrects this issue or that makes this okay. And so if I interview a witness and they say, oh, mid-level manager Joe has it totally wrong, right? I'm in the billing department, and when I see these come through, we flag them, we have a whole process, not a problem. That saves me a lot of time. It saves the government a lot of time. And honestly, it saves Joe a lot of time. And also maybe gets Joe an answer that he felt like he wasn't seeing before. So I'd say it's about 50-50 using witness interviews to support versus, kind of close out a matter.
Yeah, that's a perfect example as well. So, to talk about the risks, obviously the rewards, as Janel just said, is you get more information, you can bolster your case, or you can, close it before you get it filed if it's turns out not to be what you think it is. The risks are potentially you alert someone who's loyal to the company, loyal to the employer, and they go back and tell the employer, hey, Joe, middle management's asking a lot of questions, and I think might be thinking about filing one of these lawsuits. So Ellen, if that happens, how do you handle that situation for representing the employer?
So if we find out it's somebody who's like a current employee, obviously that creates some real issues because you can't retaliate against them. So I personally will usually reach out to someone in our employment law group here to just make sure that I'm, because a lot of those laws are state specific to make sure that we're doing what we need to do. I will certainly immediately gather whoever that potential or the actual whistleblower is, their emails and documentation, and most companies have the right to do that without alerting the employee. You have to be a little careful because sometimes they're using their work email to communicate with their counsel. So you need to reach out to Relators counsel if that's the case, to let them know, this is not a covered channel for privileged communications, but hopefully you all have, let them know that ahead of time. So that's not an issue. The reality is, though, oftentimes we can figure out who the relator is well before any sort of unsealing or any communication, if you know that the employee is a disgruntled employee who's left, of course. And so we always are trying to gather as much information about who that person is as we possibly can. Now, if they're, still employed, like I said, you've got to be really careful and how you handle that. Thankfully, that is kind of rare, at least in my experience. Most of the cases that I've been involved in on both, the government side and now on the defense side, it's often a former employee, which makes things much, much easier. But even then, once we realize who we think the relator is, we don't go broadcasting that to other employees or things like that. I sort of have a system in place where I ask questions of each employee when I'm interviewing them about various employees, right? And I include in there some former folks just to get information. But that way I'm not sort of highlighting, hey, we think, Joe Smith was the relator, such that if they're still friends with Joe Smith, they're going to go tell Joe that we're asking all sorts of questions about it. So I hope that answers your question, Jason, but it depends a lot on if they're current or former. And again, if they're current, you've just got to be really careful not to do anything that could be seen as retaliatory.
Thanks, Ellen. And, for Relators Counsel, again, another consideration there, whether you've already talked to this witness or of a potential witness, is whether to bring them in as a co-relator, right? So frequently we will have, to use Janel's example, maybe there's a nurse who says, hey, we're always doing this wrong, but I don't have access to the billing. And we don't feel like that's enough, to get, to bring this case to the government. We might send that relator back and say, you know what, if you want to talk to your friend in the billing department about being a co-relator on this case, I think that provides a different perspective. Or, I guess Janel would just contact that co-relator herself and then introduce that information in the disclosure statement. Is that right, Janel?
So I have some people come in and say right away, me and Sue in billing, we want to file this case. We want to be co-relators. We want to work together. Great. In other situations, when that isn't the case, I will treat all initial contacts initially as a witness interview. And then because my client is already signed up with me, right? I have the duty to my client. And I think that there are pros and cons to bringing on co-relators. I have that discussion with my client, and ultimately it's my client's choice. I'll make a recommendation, but ultimately, if it's something that they want to do, then we will go through this, the formal steps of bringing that witness onto the team now as a co-relator.
Right. So I'm going to discuss a little bit about gathering relevant evidence, because this is a really tricky situation. And I'm going to ask Armen to speak a little bit about how he likes it at his office and how the various U.S. Attorney's Office concerns. But obviously your first issue, especially if you're new to this, which is why you're watching this video, is how much are you going to collect, right? So, for the many first years of my practice, our policy was give us everything. My law partner liked to say, if you've got a napkin with the name of your employer on it, we want it because we know what's relevant better than you know what's relevant, right? And that continues today for a lot of cases. Anytime you put the relevance burden on your client, you don't know what's missing, right? You don't know what they're not giving you. And the example I always give is you've got an email that's like to the entire list of employees celebrating someone's birthday. Well, now I'm handing over a list of employee emails to Armen, right? You would never imagine that's a relevant thing. So at least when you begin your practice, possibly you're thinking more, give me everything. And then you can always have the client say, well, you can, ask them, what are the most important things here? What do I really need to focus on? But Armen, you're the one who's actually going to have to receive all this stuff. What is your preference? Would you rather have a document dump that has everything that our client has in their possession? Or are you preferring a more limited production so that we can focus on relevance?
Thanks, Jason. And before I say anything, I have to give the standard preamble that I'm speaking here in my personal capacity and not on behalf of the United States Attorney's Office or the Department of Justice. So with that said, I think the answer very much varies, but if I can characterize it in broad terms, it's the Goldilocks option. I generally don't like it when I get 5 documents and then later learn that Relators Counsel is sitting on a database of 25,000 documents that they've been searching and, selectively handing me documents one at a time. That can be done more efficiently, I guess I'll say. On the flip side, getting 100,000 documents that may raise a whole host of legal issues that we're going to get into is, I don't think, going to be a good use of anyone's time. So really what we want is all the key documents that the relator and Relators Counsel think are important that I should set eyes on. And if there are additional documents, alert us to that volume and what kind of documents there are so we can have more conversations about what we don't want to see and what we want to look at. I think that's going to be a theme going forward from my perspective, is constant communication and frank discussions. So we're not just, I don't see the disclosure statement as a one-time event. I see it as the start of a conversation. And I think the best way to start that conversation is to lay out all the cards and let me dig in and figure out if there's anything more that I need. And if not, we'll go from there.
Great. And just as a practice point for Relators Counsel, if you take the position of, client, give me everything in your possession, 9 times out of 10, they will not. So be ready for that. No matter how many times you go back to them and say, do we have everything? Do we have everything? Absolutely. Again, the relator interview, Armen asks a question. They say, oh, I've got a text about that. And you say, oh, rats, you didn't give me any of that. So just be prepared for that. Obviously, an ongoing issue is if your client remains employed, right? If they're a former employee, they probably have a finite number of documents. But if they're a current employee, they're going to have access to everything, right? You could be the CEO of the company, right? Has access to literally the entire treasure trove of documents. So there are some issues that can come up. Armen, do you want to talk a little bit about what happens with regards to potentially privileged documents and communications?
Yeah, this is, at least on the criminal side of things, this has been a very hot topic of late. With the decision in the Fourth Circuit, essentially questioning the department's use of taint teams to review for potentially privileged materials. And I think this is an area that there needs to be more robust conversations between the Relators Bar and U.S. Attorney's offices about what we do in cases, even before they are filed, to really head off any potentially privileged issues. It's a conversation worth having, because you can have a situation where almost everything, based on the virtue of the relator's position in the company or former position in the company is going to take the position that everything this person said is privileged. Well, suddenly the complaint and the disclosure statement by default contain potentially privileged information. Now, you may disagree with that privilege assertion. I may disagree with that privilege assertion. But if you give us just a complaint and a disclosure statement and it's distributed widely within the department, that bell is going to be hard to unring. So I think those kinds of conversations are important to have in advance, so we can properly prepare a taint team if appropriate, or ideally have a relators counsel either retain a taint team or work as a taint team to really screen off any potentially privileged information. The worst thing for me is to get anything that's potentially privileged. That just causes all sorts of headaches. It tends to be a distraction from the fraud that we're trying to investigate, and we prefer not to go down any privilege rabbit holes.
Right, and just a couple of practice pointers on that. Obviously, when you start the even really on the first call with your potential client, establish who is the counsel, right? Make sure you don't even tell me anything that came from a meeting where legal counsel was present, because just like Armen doesn't want to get booted from the case from taint, you don't want to be, right? You don't want to go through all this effort, file your case, it goes into litigation, and then Ellen finds out that you have an email, a damning email with their corporate counsel, with Ellen, right? So you want to screen yourself off from that. I'll tell you again, you can never just totally rely on your clients, right? I have a case, it literally just happened. He kept wanting to tell me, this happened in a meeting, this happened in a meeting, do not tell me. And we explained to him, you cannot tell me anything with counsel. And then he sends over some audio recordings. And fortunately for me, the very beginning of the audio recording, counsel says, I am a lawyer and this is privilege, and privilege belongs to the defendant. And I press stop, I say, let's start over again. So you want to be very careful about that kind of thing. One thing that's arising is there are taint counsels. You can hire another law firm to essentially perform your taint review for you, which, especially if you're getting a lot of documents. And I don't just mean, check 100,000 documents for lawyers, but actually go in and look and make a decision like what is privileged and what is not privileged. But we always err on the side of privilege, because like Armen said, you might not agree, but if a court decides 4 years later that you're wrong, you just ruined, Armen and yourself for this case. So I'm gonna be very careful with privilege. Armen, do you want to talk a little bit about the law regarding the gathering of evidence?
Sure. Make sure your client does it legally. Thank you. No, kidding aside, this is a area that I don't want to say we try to avoid as AUSAs, but we really lean heavily upon Relators Counsel to advise their clients about potential exposure to counterclaims they may have. The obvious example is the employment agreement that says you can't disclose any documents, everything is considered confidential and proprietary, and we will sue you if you do that. Those kinds of situations, if I'm not mistaken, the DOJ has occasionally filed statements of interest, but we don't feel that's our fight. It's really the relator's fight, but the relator should be aware that if they go collecting every single document that they can get their hands on, they may be exposing themselves to certain claims from the employer. And I think the Cafaso case out of Arizona, that's, if I'm not mistaken, it's less than 10 years old, but that's an instructive case for anyone to read up on in this area, where the relator just collected every conceivable documents, and the court was less than pleased and really focused on the fact that the relator was not collecting specific documents related to specific allegations of fraud. So just the breadth of the collection is obviously an issue that a relator should be aware of. It may be too late by the time you all get the case, but something everyone should be mindful of. I think the other issues, a lot of, especially in the healthcare context, providers and even non-providers will have this mythical view of HIPAA, that it's somehow sacrosanct. And I wish I could show you the patient records where we falsified entries, but I just can't. And, we have to occasionally have conversations with relators in that context, like, no, you actually can. There's a, HIPAA exception for whistleblowing, and in particular, when you're disclosing to the government, go right ahead and share with us. Don't be shy. Similarly, the Defend Trade Secrets Act contains an exception for disclosing materials either to the government or under seal in court. So, but again, those are conversations that we occasionally have. In general, though, that's something maybe we discuss with the Relators Council before we get into it with the relator.
Thanks, Armen. Yeah, I guess the way I would advise my clients, if give the nutshell version of CAFASO and other case law, and if you shepherdize CAFASO for your particular region, you can guess that your case law cites CAFASO, and that's CAFASSO. So rule number one is you only take documents that are relevant to the case, right? If you've got a hard drive and you don't know what's on it, and you're about to get kicked out the door, there might be a lot of you want to just copy it, right, and look at it later, and that's what got the relator in trouble in CAFASO. If you copy a lot of trade secrets and proprietary property that has nothing to do with the case, the court is not going to protect you because it didn't have anything to do with the case. The second part of that is only take documents and information that's within your purview of your employment. So, the old example is it's in the filing cabinet in your boss's office, but you don't have a key. So you go in there and you take it. But a more newer example, I hear it all the time. Hey, my friend will lend me her password and I can get anything. Well, that's not your employment, right? You're not entitled to access those documents. Well, what if this isn't really part of my employment, but it's totally under my password. If I see them, I say, yeah, that's probably okay then. Now you have to start, going to that gray area. But as long as they're not doing something funny, and they'll try to, they'll come up with reasons they can do it. So you got to really monitor that activity, and it's for their own good, right? Courts generally, to what Armen was getting at, courts have generally said that if you are taking documents for the purpose of filing a Qui Tam lawsuit, that act is protected. And that's one of the risks you're going to have to explain to them, is there's a good possibility of counterclaims for even bringing this lawsuit. Court will throw most of those out if you can prove that it was limited to bringing this lawsuit. But you have to really be clear with your clients. Don't use these for any other purpose, right? If there's even a sniff that they're maybe using it to start a competing business, or it's a client list and they're going to work for a competitor, Ellen's going to be all over that, right? She's going to attack. It's a big red flag. So last point on evidence gathering, and this is a kind of a hot issue recently as well, is protecting native formats of documents, right? And we see that with text and emails. Your client sends you over the relevant text messages and you're in discovery 5 years later and Ellen says, send me the text messages. Well, that's 3 phones ago and you don't have it on that phone anymore. All you've got is the PDFs you gave your lawyer. You might get sanctioned for that. There might be spoliation sanctions. So we, try to advise your clients, if you can't save them up somewhere, hang on to those phones. I always tell my clients, I've got my phone set to delete text messages every 2 years. People don't think about that. You got to preserve all of that, or the courts might nail you for sanctions. So now I'm going to jump into the drafting of the disclosure statement. We provided you with a checklist from Randall Fox at Kirby McInerney. We thank him for that, which is very helpful. And Janel and Armen, feel free to interrupt me if you have thoughts on this. But I think one of the biggest mistakes I see with Relators Council is they file a complaint and then they file a disclosure statement that's either copy and paste or says, hey, check out my complaint. Like it's got all of it, right? And maybe everything you've got is in the complaint, right? And you have nothing else, but that seems very unlikely. So the way I view it is I look at the complaint about, it's a legal pleading. You want to get past 9B, but you also want to preserve all of your, investigation and your legal privilege. You maybe don't want to start throwing names into the complaint that you might put into a disclosure statement. So it's a real, formulaic legal document. Just get it out there, make sure your claim is properly pled. I'm sure that another panel talks about this, but you're going to need specific examples as much as possible. Whereas the disclosure statement, maybe your complaint had a list of 100 examples. Armen probably doesn't want those 100 examples in the disclosure statement. But what you can do is in the disclosure statement say, hey, Armen, here are the documents that support each of these examples, right? You can direct him to the documents that support what you're trying to do. Now you're getting into specific names, you're getting into details. Here's the, when you go talk to my friend in billing, Janice will tell you everything, right? This is where you get into more of the things that will guide Armen in his investigation and help him. And then also part of that, you'll do your legal analysis. And different lawyers have different practices on this. I tend not to include legal analysis that I'm assuming the government knows. You might see, some disclosure statements, and I don't know how Janel does it, you might see 5 pages on what the kickback statute is. And like, here's how important the False Claims Act is. I'm like, well, this is what Armen does for a living. So I don't necessarily want that in my disclosure statement. It doesn't hurt, I guess. It just kind of, makes it a larger document. But to get back to what I was saying before, Medicare and Medicaid regulations are very specific, and you want to go into those regulations and pull it out. And, maybe it's not something that goes in the complaint, but something that goes in the disclosure statement. Medicare Advantage plans all have their own things. Armen, do you have a point of that?
Lots of thoughts. The first one is I prefer pleaded as the past tense of plead, not pled. But I think you're absolutely right about the purpose of the disclosure statement. This isn't, if it copies and pastes language about the Medicare statute, I immediately sort of realize this isn't going to help me in my investigation. You're just copying and pasting what you put in your complaint. I don't need to see that. Get to the meat, get to the point. What are the schemes that you're alleging? I think that's one great way of organizing. Sometimes, cases have 10 different allegations about this happened and then this happened. Well, can you organize it as part of a scheme? Is it part of a kickback scheme? Is it part of an upcoding scheme? What is it? Organize it as part of schemes and try to put in all the evidence. When it comes to legal analysis, I think you're right. I don't need like the obvious remuneration paid for referrals is a violation of the kickback statute. I don't need that. But if you're identifying a potential close case, look, we think this exception may apply. Arguably, we disagree. Here's why we disagree. Get into it. Let's see that up front, because that can inform our investigation about what we're focusing on when we're issuing CIDs. I can then have a conversation with defense counsel like, hey, I need to know exactly about their employment agreement. That's really going to make or break this case. Let's get all the documents about their employment agreement, just to make up a hypothetical example. That way we're not focusing on some lunch that somebody bought 3 years earlier that has nothing to do with really the make or break issue in a potential kickback case. So I don't mind legal analysis as long as it's illuminating. But I think everything else you said really hit the nail on the head. It shouldn't be a regurgitation of the complaint. It really should focus on facts and key issues, and it should almost think of it as jumpstarting our investigation, that we can look at that document. And, candidly, what I do is I look at the disclosure statement and start annotating things. Focus on this, maybe on the back burner. Not, it seems like a tough issue. Let's not, let's focus on that later, kind of a thing. And I use it as almost like a football coach using a playbook, kind of a thing. I look at it constantly.
Very helpful. Thank you, Armen. Janel?
Yeah, I kind of described the disclosure statement to my clients, as Armen just said, like, this is an investigative roadmap, right? In the disclosure statement, I wanted to tell the government, here's everything that we have, right? And some of that is facts and some of that is law. And hopefully a lot of that is documents and some of that is witnesses, right? And then here's everything else that we think is out there. And here's how we think you could go get that everything else, right? So again, I know that there's an email. I was already gone. I'm not on that email anymore, but this was my email address. Here were other people on that email, right? Certain custodians. We kept paper charts up until 2017. The paper charts are stored in the back office in the filing cabinets on the left, things like that. Sometimes I'll have even drawn a map, right, of the office or of the storage facility where the documents are. I also think, and Armen touched on this, presenting potential defenses in the disclosure statement, to me, I think is important as well. Because you got to be upfront about that stuff with the government, right? I mean, Jason, like you said, no one wants to file a complaint and then the next day get a call and say like, what's going on here, right? Like, what are you doing? So if I think that there's any issue that might lead to a what are you doing phone call, I want to have that phone call first, right? And say like, I think this is what I'm doing, you know, and this is where I'm approaching this. And if there's a workaround, or exactly like Armen said, if there's a key document and I say, look, if this document exists, it sinks our case, and I'll just be upfront about it. I think you need to request that document first. I'll put that in the disclosure statement as well. So to me, it is really that it's an investigative roadmap that I'm trying to give to the government.
Yeah, and just to build on all that, y'all reminded me of one important thing is you want to disclose your weaknesses to the government. I mean, it goes against your nature, you know, but I always tell my clients, you know, as part of the give me everything, you got to give me the bad stuff too, the stuff that's going to hurt our case, because Armen's going to get it. And you don't want Armen to get it 2 years into his investigation, and now you have to explain it away. You want to get it up front and say, Armen, I have this document, but let me explain to you why this is not what it seems, right? Ellen talked about the compliance program. You know, you don't want Armen to come back and say, hey, they have this awesome compliance program. You'd rather frame it yourself at the beginning and say, well, here's all the problems with the compliance program. So when they tell you this, like, be ready for that. I think, you know, to talk about what goes into the complaint versus disclosure statement, to build on what Armen was saying, anti-kickback statute's a great example, right? There are so many exceptions, and you maybe want to go ahead in your disclosure statement and tell Armen, they probably are going to try to fit it under one of these. Here's why I don't think it applies. You don't want to stick that in your complaint, obviously. So, Armen?
Yeah, I think what I was going to say, the being upfront is so important for a lot of different reasons. There's just a pure legalistic reason of this is what we know, and we're coming, you know, it may be dispositive to your investigation, and you want to help us with that. But I also think it builds trust, and I tend to view allegations, you know, I tend to take them more seriously when they're just brutally honest and upfront. I appreciate that. I can trust, you know, whatever you're bringing forth with your clients a little more than someone who, you know, starts every disclosure statement as this is the most egregious case of fraud ever on the United States. That, you know, that it tends to wear thin at some point, and it tends to lose effectiveness on behalf of your client, I would say. The other part is you never know what we end up discovering. That weakness that you're disclosing. Oh, I'll make up an example. There was a potential markup that was a violation of kickback rules in the defense procurement setting, but the government was a-okay with it. The contracting officer signed off. So we're putting it in our disclosure statement. It's there, but just letting you know the contracting officer signed off. And then, you know, it might be we're like, wait, that's the equivalent of axe murder in defense procurement settings. There are very hard and fast rules that you can't do that. And so, you know, from a False Claims Act lens, you're thinking, oh, there's disclosure, it's not material. But from our perspective, like, no, this is illegal in black and white illegal. And so we may pursue that when you thought you were sort of disclosing a weakness. It turns out to be something egregious. So don't feel like you need to be cagey with the government. Let us make those decisions, give us the facts, and I think all in all, it would be just way better for relators, relators counsel, and the government, and defense counsel, quite frankly.
Yeah, that's great advice. And something I will do as well is put maybe weaker claims into my disclosure statement, or claims that are not necessarily False Claims Act violations, but kind of show the integrity of the employer. Hey, Armen, they're also, just to give you an idea, they're also doing this other stuff. And in some cases, Armen has said, like he just said, that's kind of a False Claims Act violation. Here's how, or, maybe it's, like I said, patient harm or something. And I always say the False Claims Act is like nailing Al Capone for tax evasion. You can have employers for doing really terrible things, but you got to frame it as Medicare fraud. And then, that's how you get them shut down. So other things, and I've gotten a lot of great advice from Janel on things to put into disclosure statements. Witness lists. You got to index your documents. If you just give them Armen 1,000 documents, what's he going to do with that? Give him a nice index. Ideally, you identify for him what he needs to be looking at up front and what's the best documents. Sometimes weave those into your disclosure statement as citations. Janel's office likes to do draft, basically subpoenas, a CID, which I think help a lot of offices. Keywords and lingo, hey, we always call this the money train. So now Armen knows I'm going to do a search for, a request for documents to say money train. Organizational charts can help a lot of the times for very complicated large offices. And like I said, with disparaging information, I don't like putting that in my complaint if it has nothing to do with the False Claims Act case, right? I think it's just not how I like to practice. I see it, I understand it, but you can put that in your disclosure statement and not publicize these other issues, and still let Armen know that this is the kind of person we're dealing with. We didn't really talk about this, but both Armen and Janel touched on this with the pre-filing disclosure. Before you ever file your case, most offices will let you call them and encourage you to call them and vet the case with them, especially if you think there's something problematic with it, right? Hey, I've got this kickback case. I'm like 90% sure this is problematic. It could maybe fit under this. Let's flesh it out. And I've had offices basically, without talking me out of filing a case, explain why they think maybe I shouldn't file that case. And it's obviously saved a lot of hassle. I had another case, just a law I don't really understand very well. And I had a good call with the Attorney General's office, and they said, oh yeah, no, we've seen those before. Ask her about this, and this, and that develops your case before you ever even file it. So always consider reaching out to the government before you file. Work product. So disclosure statements are generally privileged. Work product, it's kind of varying law on that, whether it's opinion versus fact. You should be aware of state laws. Like Florida has a very broad sunshine law where even if it's privileged, but you gave it to the government, well, now it's part of government records. And obviously never file your disclosure statement with the court. That's rookie mistake 101. So Ellen, back to you. We file, we're in litigation and you want to know everything that the relator has told the government. Do you generally go after that in discovery?
Yeah, I mean, absolutely. We would try and get the disclosure statement, but like you said, there's sort of law that's all over the place. So it kind of depends on where you are. But yeah, we would absolutely argue that we're entitled to it and that it's not covered by attorney-client privilege or work product. And there would likely be, discussions about that. And I would be prepared for that fight, but I would never not ask for it, I guess I should say. Because if I win and I get it, it's very useful.
Yeah, right. All right, so we're going to fast forward. Now you have filed your case and, you have a 60-day seal. As I'm sure has been explained to you, that's probably going to be extended a handful of times unless your case just does not fly. I'm going to back up and make one more point. When you're preparing your case, you obviously want to research whether this case has ever been filed before. because there is a first to file bar, and you know, it's more likely than not it's under seal, but it's very helpful. You know, if you even just do a Google search and you find a press release that 2 years ago Company X settled this exact same conduct, you need to be aware that it's not going back as far as you think. And then you have to consider, hey, does Armen really want to go after these guys a second time when he's already done it, you know, in the past and gotten a successful result? So remember that part. So now you filed your case, you feel good about it, and the 60-day window, and usually, not always, but usually the government tries to interview your client in those 60 days. So Janel, tell me about your process for preparing the relator for that interview.
Yeah, I spend a lot of time with my relator preparing for the interview. Right, so most of my firm does plaintiff side employment law and litigation. And I essentially prepare my clients for relators interview the way that, you know, the other partners here at my firm prepare their clients for a deposition. So, you know, I'll tell them what to expect, right? We have one whole call that just talks about logistics, right? Who's going to be in the room? What are you wearing? What can you bring through security, right? When you're having these meetings in person at the federal building, sometimes, you know, you're taking your shoes off. So be prepared for that. Sometimes you can't bring technology into the courthouse, so be prepared for that, right? So we're talking about just getting them comfortable with all the way up to sitting down in the room, right? And who's going to be there. I'll also have a pretty in-depth call or discussion with them about the legal theories, right? I think it's important for them to understand what the False Claims Act is, the language of the statute, the 4 elements, and the schemes, right? So I try to break it down. Okay, we are alleging a kickback scheme. Here's what goes into that bucket. We are alleging an upcoding scheme. Here's what goes into that bucket, right? Because for the most part, everybody else sitting around that table is either a lawyer or has worked on these cases side by side with lawyers for a really long time. So I have found that giving them kind of an overview of the law is helpful for them in understanding what questions are being asked and what the government's really looking for in answers. And then I'll do a pretty intense mock interview. And depending on the client, I might even bring a colleague in to do like a hard cross, basically, and kind of tear down their deposition skills and build them back up, right? I give advice about use proper nouns, you know, saying I don't know is okay, always be telling the truth, right? All of these things, I go down kind of general tips and tricks for answering questions, the way that lawyers want to hear answers. And then we'll do a whole mock interview to help them kind of remember the case, because at this point, right, it's maybe 60 days after they've filed and, you know, they left the employer 6 months ago, a year ago. So it's been a while since they've thought about this stuff. So just to kind of get them back into the mindset and also to have them kind of feel prepared for what they're walking into. And it usually goes okay. For everyone, right? I don't think there's ever been tears. I'll put it that way.
I have had tears. I will say I've had
no.
So Armen, from your perspective, you know, Janel has just given you an extensive disclosure statement and like 20,000 documents. What more could you possibly want from this interview? So what are your goals and expectations when you bring a relator in for this interview?
There's, I would say, 2 overarching goals. One is to get meat on the bones. The disclosure statement gave us the skeleton. Now I want to hear the narrative explaining how what the alleged schemes were happening, who was doing it, what was the water cooler talk about the schemes happening, things like that. I'm trying to fill in everything, and preferably from firsthand information, but if not, second, third hand, whatever the relator can provide is great. So I'm trying to fill out as much factual information as I can. The second thing I'm doing is, and Janel in her prep may be trying to stymie this, is I'm trying to get a sense of what kind of a witness the relator would be if he or she is going to be my first trial witness. If I have no other witnesses to call, just a relator, how is this going to look in front of a jury, in front of a judge? Just pure presentation. So you'll get certain questions that are deeply personal and maybe ruffle the relator a little bit, but those are very much intentional and not intended to pry, and certainly not intended to make the process uncomfortable. And I'll try to, at the end, explain exactly what I was doing just so they understand and walk away. But those are really the overarching goals. In terms of the specific questioning, how we do that, do we walk through documents? Do we walk through the disclosure statement? It really varies by case and by relator. In other words, the position the relator had at the company and things like that. So it's kind of the big picture of what we're looking for in a relator interview.
And Armen, we talked with Ellen a little bit about how she tries to get a disclosure statement. What about the comments and the interview notes from this? Are these privileged?
Oh, you betcha. Yes, we take the position that we have a common interest with the relator, and if the conversations are privileged, they don't lose their privilege just because it's happening between the relator and the government, or vice versa. Now, when it comes to what the facts that the relator knows, I think the general sense is those are probably not privileged. You can't hide facts just because someone communicates it to the lawyer. But at the same time, our interview notes contain our impressions of the interview. They don't just transcribe what the relator is saying. So we take the position that notes of the interview are work product and protected.
Thanks. And Armen's office and a lot of other offices have something called a common interest agreement. We've provided a draft one of those. I'll put Armen's words out there, or put my words in Armen's mouth. The way I summarize it for my clients is it says that Armen can use anything that your client gives them, as can any government agency, and you cannot use anything that Armen gives you in return. So where this can frequently come up, and it's, as an FYI, it's really important to take notes during your relator interview, even though you're hearing the story for the millionth time. Frequently new claims come up, right? Things you didn't even think to ask. And maybe Armen ferreted out of the documents that your client provided, which is another reason to give more than to withhold, is frankly, the government knows more than you do. They know, they've seen so much more. So they can come up with cases and claims that you didn't even know your client had. So you want to be sure that you want to be very clear that you were the one who brought that to the government's attention and not vice versa. Because if Armen says, but we're also investigating them for this, and you had nothing to do with that, you cannot then go and amend your complaint to include Armen's claim. At this point, your case is filed. Your client still is like champing at the bit to keep digging up more information. They're excited because Armen's asking questions. Oh, I know where to get that information. Armen, what do we do about that?
I think this goes back to the very first point that all of you were making about the psychology of a relator. These are people who feel like they haven't been heard. You all have been prepping them about, these are lawyers and investigators and agents with guns, they're gonna eat you alive, and they come into this room, and for the first time they feel like they've been heard, and they feel maybe a little eager and anxious to help and carry on that good feeling. We have to give them very strong warnings not to continue any investigations. Once the complaint is filed, really, it's our case. We do the investigation. Anything the relator does to further the investigation can only hurt us and not help us. Obviously, in a lot of these investigations, you're talking about a small community small healthcare provider with 5 employees. I mean, word is eventually going to get out about the investigation. Certainly by once we issue a CID, word is going to get out and people are going to talk to each other. So if something comes to the relator, we admonish them to give it to you all, to Relators Council, and you all can make the decision if it's important to share with us. But generally, we have to give very strong warnings not to continue the investigation. And that, I think, unfortunately dovetails with the frustration that comes after 3 years of, hearing nothing about the investigation. Some relators tend to get antsy. I think that's something that I take personally. I think, Jason, my approach. If necessary, I'm open to having conversations directly with the relator, with their counsel on, to explain as much as I can about our investigation, where things stand. So far, every single time it's given relator, and more importantly, Relators Council, a peace of mind, and they've assuaged all the concerns. But it's something to be mindful of, the psychology of someone who's brought a complaint and yet they're sitting in limbo, not being able to move on with their life or to sort of feel a sense of redemption that their allegations were borne out.
Thanks, Armen. And obviously, a lot of the times our relators are current employees. They're still seeing things all the time. The advice we generally try to give our clients is, if something comes across your desk, you can always send it to us and we can send it to Armen. Don't start prying, don't start asking questions. So listen, but do not ask, right? Do not actively investigate. Same thing if a colleague calls you, says you won't believe what's going on at the office. Tell me about it. Listen, take notes, and call me. But then do not, don't ask a lot of questions about it. Don't pry. One last tip, just to go back on things to provide with the disclosure statement. We always provide our clients' CV. The first chunk of the investigation and interview is always, what's your background? How do you know this stuff? What's your training? Really fast forward that and help the government out. So Ellen, now you're in the middle of an investigation. You're receiving Armen's CIDs. You may or may not have a whistleblower on the premises. What do you advise your clients at this point?
Well, as soon as we get a CID from Armen, of course, we go through and, get a legal hold notice put in place, and we start doing our own sort of investigation. Often, depending on the size of the client, they may already know who the whistleblower likely is, just based on the CID alone and what it's asking for. Especially if there was only one person who dealt with that kind of thing who's been let go recently, it's pretty much very clear. And like I said previously, we do interviews. We'll obviously collect documents to be responsive to the CID, but also for our own purposes of investigating. And like I mentioned earlier, in those interviews, we ask about lots of individuals, and we will include whoever the whistleblower is. Now, if we think that we know who the whistleblower is and they're a current employee, it kind of goes back to my earlier statements. You have to be really careful. We probably won't necessarily sit down and talk to them, but we will get all of their documents and we will do a deep dive into that. And we'll probably look and see what materials they have downloaded or forwarded on and that kind of thing, just so that we know what others already apparently know about us. But really, we're just conducting an internal investigation to be responsive to Armen's requests, but so that we know what's going on and can defend. And obviously, the other thing we are trying to do is figure out what we know about the relator, because every piece of information that we can get about the whistleblower and the type of employee they were, any problems they had, were they involved in the conduct? Were they responsible for it? Did they write the policy and were, telling everybody else this is how it's supposed to go and it was wrong, or maybe it wasn't wrong. I don't know. That's our goal, because we want to, at the end of the day, obviously, explain to Armen why Relator got it wrong and we did everything right, or to minimize the potential damages. And if it's going to go forward, we want to be prepared to undermine the credibility of the Relator. So that's a lot packed into a little bit of time, but that's what we do.
Thanks. And Armen, when Ellen calls you and tells you that my client is the worst person in the world, how does that affect your case?
Ellen would never do that. Ellen is much more subtle than that. But I think what Ellen said, we try to get ahead of all that as well. And during the Relator interview, one of the questions I always ask is there anything at your time at the company or practice, whatever, that is negative? What is the company going to say about you? Was there a complaint against you with HR? Were you ostracized? Tell me everything. I want to know everything. And that goes back to the question of, how is this person going to be as a witness in front of a jury? Because that's coming, whether the person likes it or not, it's coming. And it's much better to understand that up front rather than later when Ellen calls me and says, you got a serial harasser here. We let him go. I don't know what he's telling you, but we've looked into it. Everything is done by the book. We have a gold standard compliance program. That's going to be my reaction. It's really important to get ahead of all that stuff. But by that point, by the time Ellen calls me, hopefully I have all that information and I can, again, in as direct a way as I can, tell Ellen, hey, thanks for sharing. We actually have some of that, but let's focus on request number 5, 6, and 7, which are really a concern for us based on what we know. And then she's going to go back and tell the client, pay up. they know, pay up, hopefully. But generally, that's how those interactions go.
Yeah, I should clarify, Jason. I mean, at least from my perspective, I never am of the position that strictly because of who the Relator is or their background that I think Armen and them are going to go away. A lot of it to me is sort of an education sometimes on what the position really entailed, because sometimes people think that their role is bigger than it really was, or they didn't have the full picture. And that, so really, we're just doing an internal investigation to figure out what the facts are, and then to go and try and educate, Armen on what maybe the Relator didn't know and why everything we did is on the up and up. So, but it is helpful if there's some nuggets of information as to why maybe Relator is not all that credible.
Janel,
yeah, and credibility. I'm sorry, Jason, I didn't mean to step on you, but one, this is something that I think Relators Council generally do a good job of preparing their clients, but sometimes credibility you'd be surprised what affects credibility. If I ask a Relator, why'd you bring this case? And the response is some oratory about their civic duty, fine, but you better have a good answer for my next question. Why'd you wait 6 years after you found out this was happening to bring that case? Those two aren't going to go hand in hand. And so, it's really important to suss out all those subtleties and have candid conversations with Relators that, what, it's okay that you waited 6 years. You just need to explain to the government why you waited 6 years, because at some point you're going to have to explain why you waited 6 years, whether it's Ellen in cross-examination or me in a Relators interview.
Thanks, Armen. That's a great final point. They will always ask that question: why are you filing this case? And whether it's, we tell our clients, be honest, right? You don't want to lead Armen on and think you're the greatest person in the world, and then it later come out that maybe you had some issues. So even if it's frankly a reason our clients frequently give is I needed to keep my job, right? And there's nothing inherently wrong with that answer. It's not the most attractive answer, but it's not, you want to be honest with the government on all things. So Janel, Ellen, Armen, thank you guys so much for your time and your insights. We hope everyone enjoyed this panel.